Hello, this is Matt on the Moon Lambeau channel. Attorney John Deaton has taken to Twitter to highlight what he is calling significant evidence, which frankly the SEC simply can't ignore, and it destroys their position. And this is stemming from a panel discussion back in 2019. You can see it's what's on your screen right here. I'm not going to play the video clip, but you can see there's several women here. One of them is with the SEC, and one of them also happens to be with Coinbase. And what was said here is of tremendous importance to what's going on in the SEC versus Ripple case. And I'm sure the vast majority of you know, but there's always new people coming on board. And so just to be clear, Attorney John Deaton, he's a member of the XRP community, sure, but he's also the attorney that is seeking to intervene in the SEC versus Ripple case on behalf of about 19,000 XRP holders. And so it's fascinating for a number of reasons that we'll get into here. After meeting with the SEC, Coinbase did this. Look at this headline from February 28th, 2019. They added XRP. Here's the headline. XRP is now available on Coinbase. Now, why the hell would they have done that? Well, I'm going to get into some of the specifics here. They did it because the SEC seemed to agree that it was fine and made sense and there were no problems. So look, plenty to discuss here, but before I go any further, I do want to be clear. I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and you should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos, but it's just a purely for fun hobby. That's all that's going on here, just to be super duper transparent. And so this actually started with an XRP community member who calls himself Crypto Counselor. And he notes here on his Twitter profile that he's an IP attorney. So we've actually got Twitter threads that I'm going to run through from two attorneys here. I'm going to start with this one, and then I'm going to jump over to what John Deaton had to say because he just added to it. So check this out. This is what attorney Crypto Counselor had to say about this video clip here with the panelists, including somebody from the SEC and somebody from Coinbase. Some additional interesting clips from Consensus 2019. Perspectives on SEC engagement concerning digital assets. Full video below, but comments and thoughts in following thread. Note that the participants include 1. Amy Starr, who's a chief of the Office of Capital Markets Trends in the Division of Corporate Finance at the SEC. And by the way, part of that sounds familiar. Corporate finance. That's Hinman's territory when he was working at the SEC still, Bill Hinman. 2, Dorothy DeWitt, General Counsel, Business Lines and Markets at Coinbase. Then he writes, also note that Amy gave her, quote, these are my personal views, end quote, disclaimer. I'm trying to figure out when any of these officials at the SEC ever discuss views of the agency. Perhaps the agency has no views. That's the point that I brought up so many times, and he's just nailing it there. Then he says, here's a link to a short clip, just under 7 minutes, I put together of all the juicy parts with some additional commentary below. And that's the one that I watched. The full thing was like an hour. I didn't watch that, but I think that, to get to the meat of it, I mean, that's what he did here in putting these clips together, so I did watch that one. It's interesting stuff, so check this out. Some takeaways from the video. Coinbase GC mentions approaching, working with, and the numerous conversations with the SEC. This talk, May 2019, occurred after Coinbase listed XRP on their exchange, and the listing occurred February 2019. And so Coinbase GC mentions a desire to ensure they were not listing securities. Also notes meetings with counsel, their quality legal team that does their analysis, i.e. analyzing tokens to ensure that they are not securities before Coinbase lists the tokens. XRP, obviously. And I'm telling you, like, Coinbase historically has been one of the most reserved cryptocurrency exchanges on the planet. They've opened up a little bit. They've been adding more coins, but for much of their history, there were just like a few cryptocurrencies, period. They were very careful about adding anything. And so the fact that they did ultimately add XRP, that's no small thing. That's a big thing, and they were extremely diligent. This is not something that they did on a whim. They did their homework, and they had complete confidence that XRP was not a security, and that's why they did what they did. Anyway, Crypto Counselor continues here. This analysis is done because listing a security token would be violating securities law. Coinbase GC also mentions that the laws and the SEC's approach, while developing, still creates a fairly murky area. Does fairly murky sound like fair notice? And so let me pause right there. You know what he's talking about, right? The fair notice, of course, Ripple has their fair notice defense, which is this idea that, of course, they did not have sufficient notice from the SEC that the way that they were going about conducting their business and selling XRP, they had no fair notice that what they were doing was illegal. And as it turns out, if they weren't provided fair notice and that legal defense stands, the SEC loses. That's it. And so here you have also, again, that individual from Coinbase just speaking in general about crypto, saying that things are fairly murky. So how's that? What does that say about the Ripple's fair notice defense? I think it's pretty clear. And then Crypto Counselor continues. Coinbase GC describes Coinbase's framework for listing digital assets based on Howey and case law. They worked very hard with outside counsel and think they have a great framework. You know, the framework used to decide to list XRP, which is viewed as a non-security. Coinbase GC also mentions that digital asset listings were run against the framework on a periodic basis. So up until the lawsuit was filed and Coinbase delisted XRP, their view was that XRP was not a security from February 2019 to January 2021. Almost 2 full years. And so Coinbase GC also notes that Coinbase has been transparent about their framework and the process with actual potential regulators, e.g. SEC was well aware of the process and the listing back in 2019. Oh, yes, they were, because again, SEC met with Coinbase. Sorry. Coinbase GC comments on SEC's own framework and notes that it would be helpful if there were weightings for the various factors. Basically, the framework provided by the SEC, well, better than nothing, is not really useful without weights. Coinbase GC states that the SEC's framework reinforced Hinman's view that a token can be a security and then can evolve into a non-security. Yeah, by the way, that's something that I've been talking about here, which is why it's very clear the SEC has not provided sufficient clarity, because it goes back to the Howey test. One of the prongs of the Howey test is whether or not there is a common enterprise. And whether or not something is a common enterprise, you have to look at how decentralized a cryptocurrency is to come to that determination. And there are not guidelines that would indicate what degree of decentralization must be met before something is no longer considered a common enterprise. They haven't done that, but they still insist that the SEC says they've provided sufficient legal clarity. It's all there, but it's not. It isn't. Crypto Counselor continues now. As this is said, Amy Starr, the SEC, nods in agreement, agreeing with the view on Ethereum in When Howey Met Gary Plastic. That's the famous 2018 speech where Bill Hinman says Ethereum not a security. Of course, just his personal opinion, right? Not the official view of the SEC. Anyway, he continues. Amy Starr then draws attention to Hinman's speech and specifically says, quote, again, as Director Hinman's speech had mentioned that everyone wants to remember from a legal side, end quote. So yes, the speech that apparently was not the views of the SEC, but yet again being referenced. Well, exactly, that's because the SEC wants to be able to argue whatever the hell they want to argue, whatever benefits them at the moment, without taking an official stance on pretty much anything. That's what they're doing. It's unethical behavior, but that's what they're doing. And then he wraps up by stating, Amy Starr then describes a hypothetical of a company building the best platform where people need that token to participate in that platform, and that the SEC framework would recognize that. Sound familiar to any platforms we may know? I think you know what he's getting at, my friends. XRP. And then here's what John Deaton had to say. He wrote, this is significant evidence in SEC versus Ripple, and even more significant evidence in XRP holders versus SEC. Crypto Counselor does a great job summarizing the relevant statements and admissions contained in the video shared. Some additional thoughts, and you're really going to love this. I'm glad you stuck around to this point because John Deaton really freaking knocks it out of the park here. Check this out. Amy Starr, again, this is the SEC employee. Amy Starr is likely one of the fact witnesses from the SEC that Ripple elected to depose in addition to William Hinman. Her name was brought up in the Hinman deposition. See pic. I'm not going to pull the pic up. It doesn't matter for the sake of this video, but John Deaton shared that. And then he writes, in the Consensus 2019 video, Amy states, quote, we have people that really understand the technology, end quote. Amy Starr states that at the SEC, quote, we developed an expertise, end quote, in blockchain technology, and that at the SEC, quote, we participate internationally, end quote. Why is this all significant? One, XRP was internationally recognized as a non-security. And two, the SEC was an expert and understood blockchain technology so well, yet it chose to not bring a case against Ripple or XRP for 7.5 years, even though it aggressively pursued others between 2017 and 2019. This makes the decision to file the case on Clayton's last day even more arbitrary, capricious, and suspicious. The other huge piece of evidence are the statements by Coinbase's General Counsel of Business Lines and Markets, Dorothy DeWitt. She made these three comments after Coinbase listed XRP. Most significant is that we know Coinbase met with the SEC in early 2019 to specifically discuss Coinbase's decision to list XRP. It is very likely that Coinbase met with Amy Starr, who was a, quote, senior person in the division with oversight of novel securities, end quote, and later joined the FinHub unit at the SEC. And so bottom line, Amy Starr worked for Hinman in the division of corporate finance. She apparently set up the Hinman meeting with Joe Lubin, co-founder of Ethereum and founder of Consensus. Now, Dorothy DeWitt, a general counsel at Coinbase, stated that Coinbase worked closely with the SEC and that Coinbase would, quote, analyze each token one by one to make sure they're not securities before listing them, end quote. This is directly from Coinbase. You don't think that they're acting in a whimsical manner around all this, do you? Do you think they were taking it seriously or not? I think they were taking it pretty damn seriously. Mr. Deaton continues. She said Coinbase implemented a, quote, robust analysis as possible, end quote, which, quote, included a Howey analysis, end quote, and that Coinbase, quote, felt very confident in its robust analysis, end quote. She said each token listing must be, quote, defensible before listing in the United States, end quote. She made sure to point out that Coinbase rejected tokens because they failed this robust Howey securities analysis. Even more significant, she stated that Coinbase, quote, considered the SEC's framework, end quote, and, quote, found it helpful, end quote, when developing Coinbase's own framework and determining whether a token is a security. She stated Coinbase's framework did something the SEC's framework didn't do. She stated that Coinbase's framework has weightings assigned to each individual factor. She stated that both the SEC's framework and the Coinbase framework, quote, reinforced Hinman's view that a token can start out as a security but later not be, end quote. Yeah, and so in watching that clip, she did state, too, that she said it would have been helpful if the SEC would have provided weightings to these various factors that are to be considered. But then she said, yes, but I understand that's not an easy thing to do. Something to that effect, and I'm paraphrasing there, but that's the message that was being conveyed. And then John Deaton continues here. Bottom line, at this meeting about XRP, the SEC did not disagree with the Coinbase analysis, which partly relies on the SEC's analysis that XRP is not a security. So pause there. You can see why this clearly right here is a big deal, right? It's pretty damn obvious, right? And then John continues, ladies and gentlemen, in the United States, there is no bigger market participant than Coinbase. Isn't it ironic that a huge piece of evidence that Ripple will rely on to establish its fair notice defense, that market participants reasonably believe that XRP is not a security, comes from a market participant that delisted XRP? And remember, the fair notice defense is an objective analysis. What did market participants believe? This is even more critical evidence for XRP holders. If XRP holders get a chance to be heard in this case, this is some of the evidence I will be presenting on behalf of XRP holders to show that regardless of whether XRP was a security in 2013 through 2017, it's insane to say that today's token itself is a security. Exactly. And so he just absolutely hit the nail on the head. So Crypto Counselor and John Deaton, fantastic jobs on both counts. So there you go. It's just, I love that all these old videos are being unearthed and they're getting circulated throughout the community, because just more and more evidence. As it turns out, the things that all sorts of people have said, especially from the SEC, it's actually rather damning, considering the case that they're attempting to make today surrounding their lawsuit against Ripple, claiming that XRP was sold as an unregistered security. Don't make no darn sense to Moon Lambo, a bunch of asshats marching along. Asshats marching sound like this. That's the asshats. That's exactly what they sound like. I'll go ahead and wrap up there, though. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.